afternoon, and thank you for joining us today. I am Thea Lee, president of the Economic Policy Institute. EPI uses rigorous empirical research and policy analysis to challenge some of the core assumptions of neoliberalism and to bring the voices and concerns of working people into the national, state, and local economic policy debate, with a sharp focus on worker justice and racial and gender equality. We are thrilled to launch this important and impactful intellectual project today, challenging the false and pervasive assumption that economists have foisted on the world, that workers and employers have equal and symmetrical power in the labor market. We have an extraordinarily talented and deep panel of speakers today, and I'd like to thank them for making the time to join us. This is an ambitious 3-year interdisciplinary project. We hope you will follow the project over the next couple of years and check the web page for new papers, epi.org/unequal power. I'd like to thank the William and Flora Hewlett Foundation and the Bernard and Ann Spitzer Charitable Trust for their generous support of this project. And with that, I would like to introduce our first speaker. Jennifer Harris is a senior fellow in special projects at the Hewlett Foundation, as well as a senior fellow at Brookings and the Roosevelt Institute. Jennifer?
And Thea, thank you for having me, and kudos and congratulations to the entire team at EPI for pulling together a really formidable cast of talent to explore, I think, some of the most urgent issues facing our society today. Maybe just a word on the work at the Hewlett Foundation that is supporting this project and how it links to this body of work. So as Thea alluded to, I oversee a soon-to-be launched initiative at Hewlett, which aims essentially to replace neoliberalism, which is an imperfect term for our prevailing economic philosophy, with perhaps something that works a little better. And this project was rooted in a specific history of the role that philanthropy played in bringing about neoliberalism in the first place, supporting people like Frederick Hayek and Milton Friedman, Frank Knight, the birth of the Chicago School, 50 odd years ago. And back then, their ideas actually weren't very popular initially. And it was specific things that happened in the world, crises that one couldn't have anticipated, that gave an opening. Things like stagflation gave an opening for neoliberal ideas to really take root. And so it's with that kind of evergreen hope of understanding this work isn't going to happen tomorrow, both having some urgency and impatience about it, as well as needing to fund ideas which take their time, that and in order to really move through the world, that we are kind of entering into this project, realizing it's not going to happen tomorrow, but it is I think in part about creating a movement, a shared project that connects people across both disciplines as well as domains, academics from numerous disciplines, as well as movement leaders and policymakers that will ultimately be the kind of tapestry that we need to move a new common sense about how the economy does and should work, the aims it should serve, and the role of government therein. That's, in a nutshell, the story, the work that neoliberalism is doing as a story. We need a new one. You can't fight something with nothing. And whatever else neoliberalism did, one of the essential moves that it made was to remove power and asymmetries in power from the equation. We're all just atomistic individuals competing to realize our individual preferences and through a marketplace. It's through the markets that we will realize liberty, and liberty being the chief good and the neoliberal telling. And that's not a story that accounts much for power and asymmetries in power. And so whatever else a successor to neoliberalism involves, it's going to have to involve some resurrection of an understanding, thicker understandings of power asymmetries. And I think that's one of the chief contributions that this project makes. And I'm so delighted that they have taken a really interdisciplinary tack to it, bringing forward philosophy and sort of labor market and the legal academy, as well as movement leaders, sort of feminist thinkers. There's something there for everyone, I'm sure. So let's get to it. I'll turn it back to you. Thank you.
Thank you very much, Jen. And next, I have the pleasure of introducing Larry Michel, who is the former president of the Economic Policy Institute, now a senior fellow, and he is the leader and the inspiration for this project. So Larry, we're delighted to introduce you at this point in time.
Okay. Let me, I'm hoping that this means that everybody sees the slides. No? Is that available to everybody?
Larry, we're not seeing the slides. Do you want me to pull them up?
I guess, hold on one second. Should be there now.
Yeah, Larry, just tell me when to switch the slides.
Okay, so let's just start there. So I'm really happy to have everybody join us, all the participants, and appreciate the Spitzer and Hewlett Foundation for enabling us to do this. The project is about the unequal bargaining power in the workplace. And as the first screen shows, we are announcing the website for the project, where you can find information on the 24 papers that are already commissioned and underway, as well as abstracts of the papers, bios of the authors, and information about the project. Next. The initiative stakes out that there are really 5 fundamental problems with assuming equal power, and that is that unequal power, the existence of unequal power in the workplace, takes away our freedoms both in and outside of the workplace. 2, it undermines our ability to protect workers in the workplace through constitutional, statutory, and common law. 3, it generates wage and income inequality and creates stagnation. 4th, it sabotages robust democracy. It weakens civic engagement. And 5th, unequal power impedes our ability to address race and gender discrimination in the workplace. And as I say, other than these 5 problems, it's a perfectly fine assumption, equal power. Next. Given this, it's really important that we center, that we make the default, that there is a substantial unequal power in the workplace when we think about employment law, economics, social employment and other policies, political science, and philosophy. Next. It's also important to note that unequal power is not something that is limited to just a few special imperfections. And as Alan Kruger said in a very important paper, one I think his last major paper that he delivered before his untimely death, that imperfection, meaning unequal power between workers and managers, is the rule, is the norm in the labor market. It's not the exception. So it's not just a matter of non-competes and anti-poaching agreements. It's that we have excessive unemployment, we have weak unions, we have low labor standards, we have inability to police employer conduct through the law. That's pervasive. Next. Just to review some of the thematics of the papers underway. The first is that there's 2 papers that drive home the point of unequal power sabotaging our freedom in and out of the workplace. One is focused on the erosion of free speech in and out of the workplace as a result of this. Another is the basic inability of workers to protect themselves from injury, illness, and death, as we see during this COVID crisis. Okay, another theme is the one exemplified by the paper that Sam Bagenstos is presenting today that we're releasing, and that unequal power undermines our basic abilities to protect workers in the workplace through the law. It creates differences in how employment contracts are treated versus other contracts, and it makes it hard to really enforce civil rights laws. Next. And then there's the democracy issue, and how unequal bargaining power really undermines civic engagement and democracy. Okay, we're going, there we are. And we highlight the role of employers in shaping both the policies and the enforcement of basic laws. And all of that really undermines democracy, both in and out of the workplace. Next. This is near and dear to my heart as an economist. But if you start with a competitive labor market in your mind and you assume equal power, you cannot explain really important things about the world, about the labor market. You can't understand racial disparities, gender disparities. You can't explain the suppression of wages and the rise of wage inequality. And you can't explain the fact that most workers don't actually get adequate compensation for the risks they face on the job. So it's just a failed paradigm. Next. So one of the exciting things about the initiative is that we are identifying the economic claims that have been made in employment law and philosophy that claim to support the notion that there is equal power. So we have papers which are identifying what are these economic claims, and then we have a series of papers that, in a sense, are examining them and rebutting them. Yes, employers do have power over workers, and the ability to quit doesn't prevent exploitation. No, you cannot assume away or ignore the fact that we are rarely at full employment, and even when we are at full employment, most workers are actually not at full employment. There's a political science literature on the varieties of capitalism that shows that nations can make choices to get less inequality, and it doesn't really hurt economic performance. And last, no, it's not true that we cannot constrain management rights, or the notion that if you constrain management rights, the economy will fall apart and firms won't be able to function. We know this from what's happened with mandates on minimum wages and other compensation, on constraints that have happened that relate to employment flexibility. Countries which have less so-called flexibility have done just as well as those with supposedly more flexibility. And last, even policies like co-determination, which really do impinge on management rights, do not seem to impede a firm's ability to compete, to invest, to have profits. And last, or next, we are having a series of case studies of exploited workers so that we can actually illustrate the phenomena that the more abstract papers are talking about. So next, please stay tuned in. There's going to be many public forums. We will be having convenings. We'll try to figure out how to do that in a COVID era. We're going to synthesize and disseminate all the findings and put it in publicly accessible formats over the next 2 years, and engage the public, engage rank and file activists, engage policymakers, engage the media. So please stay in touch, follow the website, and thank you all very much. Oh, and last, I should say, I want to introduce Kate Andreas, who's professor of law at the University of Michigan, an employment lawyer, labor lawyer. And one of the inspirations of this initiative was the dissent of Ruth Bader Ginsburg, Justice Ginsburg, in Epic Systems. And so we wanted Kate, who was a clerk to Justice Ginsburg, to say a little bit about that. And thank you for inaugurating the dedication to Ruth Bader Ginsburg. Thank you, Kate.
Thank you for having me. Thank you for having me. I'm delighted and saddened to be here today. I'm delighted because the work that this project is undertaking is important and urgent, and I'm very excited about its potential, but also saddened because I'm here in the stead of my former boss, Justice Ruth Bader Ginsburg, Her death was a personal loss for those of us who were privileged to know her, but more important, it was a terrible loss for our nation. Indeed, I think it is tempting to despair. The Supreme Court will soon likely have a 6-3 conservative majority for a time at least, and will pose a grave threat both to the existing rights of working people and to legislative reform that might be won in the future. But those of us who knew Justice Ginsburg know that were she in our place, she would not despair. She would soldier on without missing a beat. So we have an extraordinary challenge to continue her work, to continue her legacy, even in the face of some very significant obstacles. And EPI has taken up this challenge. When we talk about Justice Ginsburg's legacy, we tend to focus on her path-marking work on gender equality. Her brilliant and careful work as an ACLU attorney and later as a jurist eradicated legal classifications that rested on gender stereotypes and opened up a world of possibilities for both men and women. But Justice Ginsburg's legacy reaches beyond the issue of gender equality. One area of her jurisprudence that's less appreciated is her work on labor and employment issues more broadly. In case after case involving workers, she detailed the on-the-ground, lived experience of working people. And in so doing, she illuminated the persistent power imbalances in employment relations. Epic Systems versus Lewis, decided in 2018, really epitomizes this approach. In that case, the Supreme Court, by a 5-4 majority, held that an employer may block employees from pursuing their legal rights in concert. That is, the majority held that an employer may force its employees to agree as a condition of employment to arbitrate all employment-related disputes on an individual basis, waiving their rights to participate in class action lawsuits or collective arbitrations. The majority, in an opinion authored by Justice Gorsuch, turned a blind eye to the deep power imbalances that characterize the workplace, while also ignoring the clear command of US labor laws. Justice Gorsuch asked, should, quote, employees and employers be allowed to agree to arbitrate disputes? Put differently, he basically asked, should employees have the liberty to give away their rights? Justice Ginsburg, building on the important arguments that have been offered by the NLRB in its briefing, showed why the court's argument so terribly missed the mark. She wrote, and I'm quoting, to explain why the court's decision is egregiously wrong, I first refer to the extreme imbalances once prevalent in our nation's workplaces and Congress's aim in the Norris-LaGuardia Act and the National Labor Relations Act to place employers and employees on more equal footing. It was once the dominant view of this court that the right of a person to sell his labor upon such terms as he deems proper is the same as the right of the purchaser of labor to prescribe working conditions. But the Norris-LaGuardia Act and the NLRA operate on a different premise, that employees must have the capacity to act collectively in order to match their employer's clout in setting terms and conditions of employment. And as Justice Ginsburg emphasized, the quote, edict that employees with wage and hour claims may seek relief only one by one does not come from Congress. It is the result of take it or leave it labor contracts, harking back to the type called yellow dog, and of the readiness of this court to enforce those unbargained for and arm-twisted agreements. In short, Justice Ginsburg warned that the court was hearkening back to the era of Lochner, the era where the court repeatedly struck down democratically enacted legislation aimed at protecting workers' rights, the era where the court safeguarded employers' rights to insist on arm-twisted contracts, the era where the court constitutionalized power imbalances in the workplace. EPI has taken on the urgent task of refuting this approach, the urgent task of making Justice Ginsburg's assessment of unequal workplace bargaining power the common sense and core framework in economics, law, and philosophy. That is the purpose of EPI's initiative on equal bargaining power. And on this day, the initiative is being dedicated to Justice Ruth Bader Ginsburg. And so thank you, EPI, for this very important work.
We now have a panel, and to moderate the panel is Cindy Eslin, a law professor at NYU. I promise not to give long introductions to everybody, so I won't, but I'm really glad to put you all in her good hands. Cindy.
Well, thank you so much. I am very pleased to be part of this important and timely project. I say timely. Of course, at the moment, it can be hard to focus on anything but the day's latest outrage. But one thing I think is very clear, that we're going to emerge from the current public health and economic crisis with an even more polarized and unequal economy than we entered it with. And that was a pretty bleak starting point. So this project aims to illuminate what we might call the most basic building blocks of the unequal economy, and that is inequality within the individual employment relationship. So let me just give you a quick preview of the proceedings for this panel discussion and some very, very brief introductions. We're going to hear first from Professor Samuel Bagenstos, who is the Frank G. Millard Professor of Law at the University of Michigan. And he's going to start us off with a brief presentation on the continuing influence of long discredited formalistic conceptions of the employment relationship in the law. Then we're going to go to what Larry has named the lightning round, with some very short reflections on the problem of unequal bargaining power at work from several disciplinary perspectives. We're going to hear from Professor Elizabeth Anderson, who is the Arthur F. Thurnau Professor and John Dewey Distinguished University Professor of Philosophy and Women's Studies at the University of Michigan. Then we'll hear from Alexander Hertel Fernandez, a political scientist who is Associate Professor of International and Public Affairs at Columbia University. Then we'll turn to a colleague of Alexander's, Suresh Naidu, an economist and also professor, a full professor of International and Public Affairs at Columbia. And then finally, Jenny Yang, who is a senior fellow at the Urban Institute and former chair of the Equal Employment Opportunity Commission. Then we're going to open it up for discussion among the panelists, and I've promised to wind things up by 6 o'clock Eastern time. So Sam, why don't you take it away?
Okay, thanks so much, Cindy. And thank you to Larry and to Thea and to EPI, and thanks to Kate and all my terrific fellow panelists. I'm actually much more interested to hear what you all have to say than what I have to say. This is just an incredibly important initiative for all the reasons that people have explained. What my task is for today is to sort of present in about 6.5 minutes now the paper that I was asked to produce for this project, and the paper is basically it's entitled something like Lochner Lives, and I keep thinking about the old horror movies It's Alive. So let me explain what Lochner is. Many of you on this webinar know, but many may not, and how it lives. So what is Lochner? Lochner is both a case decided by the Supreme Court and an entire era of the Supreme Court's jurisprudence. So it's a case decided by the Supreme Court in 1905, basically in response to progressive era legislation protecting workers, limiting the number of hours that bakers could work in New York State. The Supreme Court held that this law was a violation of the Due Process Clause because it violated what it understood to be a fundamental right to contract. But the name sort of stands in for an entire era when you had courts, including but not limited to the Supreme Court, standing in the way of populist era and progressive era legislation designed to protect individuals in the labor market. And there are two very crucial aspects of Lochner that I want to talk about. One is that Lochner, both the case and the cases of the era, overrode democratic decisions to provide protections for people in the labor market, and in particular to rectify what was understood to be an imbalance of power between workers and their employers. So first, overriding democratic decisions to rectify imbalances of power, and secondly, that Lochner, the case and the cases of the era, were based on the premise that workers and their employers had equal bargaining power. And I'll just read you a couple of quick quotes from these decisions to give you a sense of what at least the justification for these decisions were. So in Lochner itself, the court described maximum hours laws as, quote, mere meddlesome interferences with the rights of the individual. I mean, it's got this whole idea of you get the overtone of the nanny state. They, quote, limit the hours in which grown and intelligent men may labor to earn their living. And the court said, look, there's no reason to believe that bakers as a class are not equal in intelligence and capacity to men in other trades, or that they're not able to assert their rights and care for themselves without the protecting arm of the state. They're in no sense wards of the state. There's this idea that comes out of Lochner that people can be relied on to make their own best deals. And you see in these cases a clear ideology that the court thinks that it's protecting both workers and employers when it's overriding these laws that are designed to protect employers. So in another case, the court says the right of a person to sell his labor on such terms as he deems proper is in essence the same as the right of the purchaser of that labor to prescribe the conditions upon which he will accept it. In all such conditions, the employer and the employee have equality of right, and anything that disturbs that is arbitrary. Now, the standard story is that Lochner was rejected in the New Deal, that when the Supreme Court upheld the National Labor Relations Act, upheld wage and hour regulation, it rejected Lochner. And in constitutional law, that is correct. But in labor and employment law, Lochner lives. And so I talk in the paper about a number of areas. I'm just going to talk about a couple right now where you see both the premise of equal bargaining power and the overriding of democratic decisions to protect workers. One is, and I draw on Cindy Eslin's terrific longstanding work in this area on this, one is the basic baseline premise of employment at will. The idea in American law from the common law is, at least from the late 19th century, is that either party to an employment relationship is free to terminate that relationship at any time for a good reason, for a bad reason, or for no reason at all. The principal justifications for that are based on equal bargaining power. The idea is, well, both sides can terminate the relationship whenever they want. Obviously, it's really important for workers to be able to do that, or else they're held in slavery. But as a practical matter, it is the employer who has the most power in that relationship. And when the employment at will presumption has taken hold in the law, courts have used it to undermine protections that legislatures have adopted against discrimination in the workplace, against retaliation for speaking out in the workplace, protections of workers' privacy, etc. Second, who is an employee? Most labor and employment laws apply only to people who are determined to be employees. The standard tests for determining what is an employee versus an independent contractor depend on the contractual relationship between the worker and the employer. So what a court will do is it will say, look, if on the terms of your relationship with your employer, you are controlled by that employer or you are not controlled by that employer, that's going to determine whether you are entitled to the protections that legislatures have adopted. But of course, that too is based on the idea that when I go to work for somebody, I have some power to determine the nature of the relationship that I'm under, which is simply not true. And then finally is the example that kicked off Kate's comments, which is arbitration. Where the Supreme Court in the Epic Systems case that Kate referred to said that, well, workers just can make a choice to give up their rights to go to court to enforce employment and labor laws passed by Congress. But of course, the choice is no choice at all, in part because they can't leave the job, but they often, it's a take it or leave it decision, as Justice Ginsburg said, in part because in a case like Epic Systems, and very typically, the so-called agreement is something that is provided either as one of a stack of many papers a person signs on their first day of work. It's something they click through when they're making a job application online, or in Epic Systems itself, it was an email that the employees got in the middle of the night saying, if you show up tomorrow, you've agreed to this to this arbitration provision, all of which is undermining and making it impossible to enforce the laws that are passed by democratically accountable legislatures to protect employees and workers. And so this is why I say that Lochner, this idea that workers have equal bargaining power with their employers, and this use of that idea to override democratic decisions to protect workers lives today. And now I'm really interested in engaging in our conversation.
All right, thank you, Sam, for getting us started out. I would love to have a conversation with you about this sometime in or outside of this discussion. But right now, let me hand it over to Liz. Liz, you've recently cast a philosophical eye on the problem of unequal bargaining power at work. So how does unequal bargaining power in the workplace lead to other kinds of power differentials between employers and workers?
I think this is really critical. Once you get unequal bargaining power, essentially the content of the labor contract is imposed on workers in the vast majority of cases with no bargaining at all being offered to workers. They're not even given the opportunity to bargain. They're just handed a contract. And indeed, most of the time, the contract isn't even written. So workers don't even know what rights they might have or don't have, because it's an oral contract. Unequal bargaining power leads to unequal power between employers and workers in the conduct of day-to-day life, importantly, both at work and off duty. Employers rule workers' lives, even in matters that are completely unrelated to efficient production. So at work, unequal bargaining power interacts with the law of the governance of enterprises, where all the power is already held by the owner of the enterprise or the shareholders, and then derivatively by management, which is appointed by or elected by the shareholders. Essentially, the constitution of the government of the firm is a dictatorship. Okay, and that's just built into the interaction of an employment at will regime with the fact that the governors of a firm are the owners. And that leads to comprehensive rule within the firm of employers over employees' lives, comprehensive surveillance of everything they say or do online, surveillance of their speech. They don't have any privacy rights. Often they can be inspected. And they don't even get paid often when their persons are inspected to check, say, if they've shoplifted anything. They can be subjected to arbitrary drug tests outside of any need to secure safety. Importantly, they don't have any control over their time, over their schedule, the time schedule. They might not even be informed of their schedule except a few days in advance. And by then, it could wreak chaos with their lives. How do they arrange daycare, childcare? How could they take courses at the local community college if their employer says, no, sorry, you just got to show up for work this week. They got to miss their course. It creates chaos in their private lives. And that's the second issue. Employer rule over workers' lives does not stop just when people leave work. It continues after work. If you can control the hours somebody has to show up, and it's arbitrarily irregular from week to week, that means you also wreak havoc with people's private off-duty lives. And in addition, workers don't even have freedom of speech off-duty. They could be fired for taking a political position, say on their Facebook page that the boss disapproves of. They could be fired for recreational activity that their boss disapproves of, sexual activity that their boss disapproves of, even though this has nothing to do with the efficiency of production. So in fact, the dictatorship of workers, of overworkers by employers even continues off duty. But I want to stress that there's an interaction here between the employment at will regime that Sam talks about and the fact that we also have laws regulating the governance of the firm, and that could be changed. In Germany, they have co-determination, where management is joint between workers and managers, and that could be a way to bring power back to workers that isn't all mediated by the courts. And I think that's something we really need to put on our agenda today. Thank you.
Thank you so much, Liz. I'm going to turn to Alex. You're a political scientist and you've taken an empirical look at some of these issues. What can you tell us about the political and civic significance of the workplace and employer power over employees at work?
Sure. Thanks so much for the question, Cindy. It's a real pleasure to be here for a variety of reasons, but especially because as a former EPIer, it's terrific to come home to this great institution. So the first thing to say is that the workplace has enormous potential to serve as a site for civic engagement, knowledge building, skill building, and participation. The potential is there because unlike other places in our lives, we don't tend to choose our workplaces on the basis of our political views. Indeed, some of the work I've done for the brief for this project highlights the fact that we haven't seen a big sort in the workplace in the same way that we have in many other institutions of our lives. So you have a potential to be working alongside people who don't share your views, who come from different backgrounds, and in the process, learning more about different political issues and gaining an appreciation for the other side. In addition, many of the skills that people learn on the job have the potential to spill over into politics, whether it's how to talk to someone else who has different views from you, whether it's to how to run a meeting, public speaking in general. And there's also important ways that people can build knowledge and connection that they can leverage into politics, whether it's learning about something that's being debated in a particular election or a current event that affects your life. So there are real potential there for the workplace to serve as this site of democracy and citizenship. But there are ways in which I think unequal bargaining power really erodes that. And there are ways that this has always been present in the American labor market, but then layered on top of that are worrisome trends that have emerged in the past few decades as workers have lost standing in a variety of ways, but especially with the erosion of the labor movement. So how does unequal bargaining power shape the civic potential of the workplace? Well, first, in all the ways that Liz just described and that Sam underscored, at-will employment with insecure employment relationships chills political participation as workers fear speaking out and engaging with their coworkers for fear of retaliation or punishment from their managers and supervisors. As we heard, employers have a great deal of control over workers, both on the job and off the job. Second, the decline of labor unions, which itself is implicated in this unequal bargaining power relationship, means that workers just have far fewer opportunities to engage in politics on the job. And that's especially true for low-wage workers, workers with less formal education. Unions play an important equalizing role in providing political information and skills to workers in the workplace that they don't get otherwise in their lives. So the erosion of labor unions has really widened inequalities in political and civic participation. And the last way in which it matters is at the level of democracy and government. Labor unions are one of the few institutions that lobbies on behalf of low-income and middle-income Americans. And so by removing them from the political process, you're really creating vast political inequalities in representation. There's no one to check concentrated power of economic elites in the political process.
Okay, thank you so much. That's a daunting set of problems. So Jenny, let me turn it to you. You've devoted your career to advancing inclusion and equal opportunity at work. So how does unequal power at work affect workers' ability to challenge discrimination and harassment where, Congress has intervened, there are statutes? How does unequal power sneak in there to undermine those laws?
Well, thanks so much, Cindy. In the anti-discrimination space, the laws have not grappled with this problem that there is a fundamental imbalance of power as well as information asymmetry. So I'll highlight a few of the legal doctrines that have really undermined the effectiveness of these laws. And the first is the way in which our complaint system is structured, right? So our primary way of learning about discrimination, back when I was at the EEOC, is for individuals to come forward and publicly accuse their employer of discrimination. right? Very few people will do that. And even fewer will do that if there is not an effective, well-funded agency that can actually protect workers from retaliation. What we saw from the Me Too movement, research shows 99.8% of workers experiencing sexual harassment will never come forward. Two-thirds at least of workers who file a complaint will file a charge of retaliation, and many of those workers will be fired. So we have a system that fails to recognize how vulnerable workers are. And it isn't just that you might be fired from one employer. You could be blackballed and have to really leave an entire field. And so that is the system that we've set up that fails to really wrestle with that power imbalance in requiring this kind of public complaint system and having an under-resourced enforcement agency that could play a role in rebalancing the power and should play a role, but often does not have the resources to do that. Another critical problem is the information asymmetry between workers and employers. Typically, employers have all the information about what the policy is, who else is affected, how the system works, yet our legal system requires the individual worker to have sufficient information to even file a complaint. And often there's actually no way to get that kind of information. So we see a series of judicially created rules that set very high hurdles for workers who want to file a complaint. Often they're being dismissed at their complaint level or later on in the process. So we're seeing with, for example, employer efforts to use artificial intelligence and algorithmic hiring screens, right? Employers have all the information about how those systems work. We can't possibly expect that an individual worker will ever have enough information to challenge those kinds of systems. The other challenge that we see is there's just a fundamental both resource and power imbalance that affects the contractual terms, right? We heard from Sam and others earlier about the problems of mandatory arbitration, and that significantly undermines the enforcement of anti-discrimination laws. Because if workers cannot even learn about problems that others have, they are not going to be able to come forward. If they have to waive their right to bring a class action, they can't rely on the evidence that you often need of a systemic practice. So our laws have allowed employers to use that power in the relationship to actually take away rights from workers, to require non-disclosure agreements so that other people can't find out about the problems, to agree in resolving a case that you won't ever apply to that employer again, which can limit your employment options in the future. So for us to really address these, the under-enforcement of our anti-discrimination laws, we do really need to reckon with this fundamental power imbalance to revitalize our enforcement systems and also to put much more responsibility on employers at the front end to disclose information through things like the pay data reporting that we led at the EOC. Those kinds of systems can encourage, create greater incentives for compliance by employers at the front end rather than putting an inordinate burden on workers to try to prove this all after they've experienced discrimination. Thank you.
Thank you so much, Jenny. I accidentally skipped over Suresh, but it's actually suitable that the economists should come last because economists get a lot of the blame for how the courts view employment relations. So what does economics tell us now about the role of power in the labor market?
Thanks for the question and thanks for being with, appreciate being on the panel. So let me start with I think an underpinning of a lot of this is that, say an economist circa 1980 might say, yeah, but if you don't like it, you can just quit. And that's kind of often a response to all kinds of ills in discrimination or scheduling or amenities or any of these things. It's like, well, if you don't like it, you can always quit. And one of the things that we've been looking at, I think recently in economics, particularly with the advent of administrative data on workers and firms and sort of looking at, and paradoxically, I think the gig economy has actually made it easier to run experiments where you randomize the wage for a particular job and see what fraction of people quit. And so we can pose these thought experiments of like, well, how easy is, and these actual experiments of how easy is it to actually quit? So imagine the following, like if your employer cut your wage by 10%, what fraction of workers would you think would leave in the next year, in the next 2 years? And so somebody might think, the competitive standard model would say basically everyone would quit instantaneously. And now we have pretty good estimates of that number. And it's somewhere around 20%, 20 to 30%. And so that's not nothing. So people do leave if you cut their wages, but it's not everyone. And so it's like that, and it's not, and so that a lot of people will stay. And it's because, a job is hard. Jobs as good as the one you've got are few and far between. And particularly when there's persistent unemployment. And so employers know that. So that means that wages are always a little bit below what they should be because an employer is willing to tolerate a bit of additional turnover in order to make profits off all of the people that stay. And so you get kind of a stable rate of exploitation. And you can get, so an upshot of this view is that you can kind of start to make sense of like lots of different other things about the labor market. So all the points Liz and Jenny brought up sort of become sort of at least like maybe everyone else understands them, but it takes a while for economists to understand them. It's that, for example, like on the issues of discrimination, right? Employers now want to use tags. So they want to figure out who's willing to leave and who has better outside options, who's willing to leave. And so gender and racial disparities become legible as like tags that you're like, hey, I know this person's not going to leave. And so I can get away with like lowballing their wage because they're less likely to quit. Or similarly, like I can post, I can alter people's schedules. I can tolerate certain workplace cultures because I don't have to worry about everybody quitting. And so, and another implication of this is that employers are always hungry for workers at this level. So it's like, because they're making profits off every additional worker, they'll always be complaining about skill shortages and lack and an absence of workers. And it's like, oh, we can never get enough people. And it's like, well, have you tried offering a higher wage? And that sort of never comes up as one of the as one of the options. And so and so I think like a lot of the issues raised by other people on the panel just really become intelligible inside economics once you get that, like in technical terms, like the quit elasticity isn't 10, it's something like 2. And so there's like, so it's not that markets don't work, but it's not that but there's enough slack in them that there's a substantial role for institutions of governance, for regulation, for interventions to kind of really handle this kind of imbalance in the labor market.
Okay, I'm sure we're gonna hear more from you about some of the changes and how economists view these things. But let me kick things back to the panel and start off the discussion by asking what's changed. What I mean is, back in the day, the Lochner era that Sam described, the legislature was not empowered to put statutory restraints on the individual employment contract. We couldn't have minimum wages, we couldn't have maximum hours laws, nor in effect could workers unionize, because the court was putting all sorts of barriers in the way of unionization as well. But okay, the New Deal kind of settled this for a while and said, okay, it's not enough that you can quit. You also have the protection of the legislature, which puts boundaries on how much the employer's bargaining power can actually dictate. How low can you go? How bad can it get, right? And but then, if that's not enough, you can join with your fellow workers and form a union. So why isn't that good enough? What's changed? That was thought, those two approaches, legislation and collective bargaining, were thought to be the embodiment of the recognition that, in fact, workers don't have enough individual bargaining power. So I think this question is, I mean, in the first instance, maybe for Sam, but really everybody could chime in on that.
Yeah, I mean, I think a bunch of things changed, right? I mean, one thing that changed was politics changed, so the neoliberalism that this whole project is sort of a part of an opposition to kind of came in and took hold of the political environment, leading to different judicial nominations of people who were not as supportive of these kinds of protections, but also different efforts to undermine unionization, right? And so you see the decline of unionization. Part of that is about economic changes, but a big part of that is about politics. It's about the state no longer supporting unions. And I think all of these things work together to lead to a situation where this neoliberal ideology is that you can walk away. You don't like it, make a deal with someone else. These ideas really grow in the legal academy. They grow in influence among policymakers, and they influence judges and legislators as well. And so I think you see all that. And what makes it not move back to the Constitution is Lochnerism as constitutional has become so discredited and has become such a cudgel for right-wingers to use against people on the left who want to use the Constitution to protect a woman's right to control her body or to protect marriage equality, right? And so they're not going to do the big overt Lochnerism anymore, but they're going to do the same thing through 1,000 little decisions that fly below the radar, and that's what we've seen.
So I'm wondering, Suresh, whether there are also changes in the economy that have kind of altered the effectiveness of that two-pronged response of legislation to set boundaries on the labor market and collective bargaining.
So I don't think anyone would say that there hasn't been substantial structural change in the economy. And I think, the rise of the service, the transformation of the economy from manufacturing to services, and just the fact that new unionization didn't keep pace in the service sector in anything like anything like it needed to be. That's certainly part of the story. And another part of the story has got to be globalization and the fact that capital is mobile in a way that labor is not across borders. But I also want to sort of push it back to the panel that suggests that even globalization is contestable in law and institutions. So I like to think of this Darlington Mills case where I always forget the details, but South Carolina textile mill, whether or not it actually had to bargain over the right to leave. And this went up to the Supreme Court, and the Supreme Court said that you didn't that the union had no claim on the mill's right to relocate. And so I often wonder if the Supreme Court had said, no, you actually do have to bargain over the decision to relocate, would we have a globalization that happened on different terms, or were there ways in which that you could have imagined that that you could have dampened the capital flight threat by means of sort of redesigning institutions or covering the real changes in economic openness with things like changes in the scope of duty to bargain and things like that? I ask you guys, so that's.
And Cindy, if I could just pick up on that point about changing workplace structures, it's had an impact in the equal employment opportunity space as well. To Sam's point earlier, if you have an increasing independent contractor workforce, including but not limited to the gig workforce, you have a whole category of workers who are not covered by anti-discrimination laws. Then you have the problem with having to prove, right, that you're actually an employee and you've been misclassified. And most of our laws put that burden on workers, when again, it's the employers who have all the information, and really it should be their burden to demonstrate that people are properly classified. But then you have other structures like an increasing reliance on temporary work. And so what you'll see is you have multiple employers, right? And the employer that may actually control the work site does not believe it has responsibility or is the actual employer of that temporary worker. So what we saw at the EOC was, for example, a worker placed by a staffing agency at a warehouse is sexually harassed by her manager at that warehouse. She never got any information about the complaint process And then her manager said, if you come forward, you'll be fired because I run this place. And she came forward and was fired. And the EEOC had to go to trial to litigate that. So that is one of the problems where you have these attenuated responsibility structures because of the subcontracting relationships. And it becomes very difficult for employers to even know, employees to know who their employer is and to actually hold them accountable under our laws.
I would just add quickly, picking up on that. Oh,
go ahead.
Picking up on both Jenny and Suresh's point, so much of the story of what has happened in the workplace is a failure to update the laws that we have, and that was a deliberate political choice. In fact, one of the political science contributors to this project, Dan Galvin, has written very persuasively about how the lack of updating of key labor institutions, above all the National Labor Relations Act that is work site focused rather than focused on industries, regions, or the country as a whole, was always poorly suited and disadvantaged labor, but especially so as you see all of these trends that the other panelists have put forward, whether that's the transition to the service economy, or as Jenny mentioned, the move to independent contract work or temporary help work. The other thing I would mention is that driver behind so much of the stasis has been a vast political mobilization of capital through new organizations, new strategies, new tactics. And so that has made the need for a labor counterweight to that, to business in politics, all the more essential. And yet now is when we don't have that.
So Alex, that's a perfect opener for me to ask you about your earlier research about, you talked about a mobilization of capital, but you've written about how employers are leveraging their own power by mobilizing their employees on their own behalf in the political sphere. So I think that's just a great illustration. If you could talk a minute or two about that, of how employer power over workers inside the workplace gets magnified and elevated into the political sphere. And that's from your comments, I'd love to hear Liz's views on this as well.
Yeah, so in recent years, you've seen businesses becoming more comfortable asking their employees to participate in politics in various ways. And that can range from things that we might view as relatively benign, like asking employees to register to vote, helping them to find their polling place, or even giving them time off if the law doesn't require the employer to do that, to things that might shade into more coercive practices that we might be more concerned about. For instance, endorsing candidates, requiring employees to show up to rallies, make contributions to particular candidates. And the reason why this is especially worrisome is that we've seen a total failure of the federal government to regulate this, between the at-will system that allows employers to have a great deal of free rein and places the burden on employees to report and file any violations that might happen, along with a broken campaign finance system, just creates a whole new terrain for employers to engage in these practices. And as I documented in my first book, this has been an increasing tendency of businesses over the years.
So Liz, I think in your book on private government, you talk also about how the power to fire employees at will can become the power to dictate employee behavior both inside and outside the workplace. Now, obviously, there's lots of reasons you're not allowed to fire people nowadays, unlike back in the Lochner era. Most importantly, discrimination laws, but there's all sorts of retaliation laws. One thing we don't have is any comprehensive protection against the kinds of pressures and retaliation, potential retaliation that Alex is talking about. So I wondered if you could just say a bit more about how that employment at will, and to Liz, because I know that you've written about this, how employment at will becomes a source of employer power over employees' lives in a much more comprehensive way.
Well, yes, and I wanted to pick up actually on the previous points about plutocracy, because unequal bargaining power ultimately is a system rigged by the state and the laws that it makes. You go back and you read Adam Smith in The Wealth of Nations, Book 1, Chapter 8. He identifies unequal bargaining power as at the core of the unequal general power that workers have in relation to their employers. And he pointed to plutocracy as the cause of this. He said, you know, whenever Parliament passes laws, its counselors are always the masters, that is the employers, right? Who else are they going to listen to? All the members of Parliament are masters, right? They're either landlords or they're big industrialists, okay? And who are they listening to? They're listening to their friends and to the people who support them politically. That's where they get their ideas. How is it any different today? There's only one member of the Senate and maybe even all of Congress these days who's has working class background. Well, he's not even a member anymore. Joe Biden. He's the only guy who wasn't a millionaire until recently. Okay, they're all a bunch of rich people who pal around with rich people. They're completely out of touch with working class concerns. So it's not a surprise that we're not seeing a lot of legislation on behalf of workers, on top of which they're completely beholden to our campaign finance system and spending far more time raising money from rich people to support their campaigns than they are actually investigating the problems that workers suffer from and trying to design legislation to help them out.
Well, you started to answer my next question, but of course, when you quoted Adam Smith and plutocracy, of course, one thing that's changed since then is that workers have the vote. And so the workers who are at the bottom end of this unequal bargaining power, in the aggregate, you'd think they would have enough voting power to enact decent legislation, to a better kind of labor law. Why haven't workers collectively in their political guise managed to form an effective coalition for protecting their rights both at work and beyond?
That's what they depended on labor unions for. And now only a tiny percent of private sector workers are unionized. And the public unions too, the state, of civil servants have also been radically disempowered in many states.
Other thoughts on that question?
Well, I mean, I'll just say, all of these developments kind of ramify on each other, right? So why have labor unions, declined so much? Some of it is, there have been changes in the economy, but I really do want to pick up on the point that Suresh made, that it really is as much about how the law responds to changes in the economy and the kinds of changes that the law encourages as just these are external changes out there that the law can't help but fall apart in the face of. So when we have the Supreme Court essentially declaring as a constitutional matter that every public sector union in America has to be right to work, right? That's the Supreme Court using the Constitution in a way that significantly weakens labor power. And of course, when they weaken labor power, that means that labor has less power to push the enactment of these laws. And that means that they have less power to affect who gets to be the judges. We have Alex's point about the way the laws don't constrain employers from regulating the out-of-work political speech of their employees or regulating the at-work political speech of their employees, right? I mean, there's actually been a whole series of cases involving that in state common law courts involving, wrongful discharge doctrine, which generally says that employers can't fire people for their speech that has, third-party effects. And the courts have nearly uniformly rejected applying wrongful discharge doctrine to employers firing their workers because they don't like their workers' out-of-work politics. And there are all these absurd examples of people getting fired for their out-of-work politics. And when the courts reject these claims, they say, well, look, we have employment at will in this country. You can fire someone for whatever reason you want. And then that makes it much easier again for the employers to use their power over people at work, as Liz says, to leverage that into power in politics. So all these things, they build on each other. And unless there's a way of, rebuilding collective worker power in the face of that, this is the situation we're faced with.
I do think we're seeing pockets of organizing, like the Fight for 15, right, where workers are getting together and really demanding better working conditions at the local level.
I would just shout out to another great contribution to this initiative from Janice Fine and Hannah Shepard, who are looking at cases where cities in particular have taken action around the minimum wage, around enforcement of labor standards. But so much of what they're discovering is that enforcement really depends on having a robust set of labor organizations, whether they're unions or alt labor groups like worker centers. And so it comes back to this question of organization. It's not enough to elect pro-labor politicians or even get them to pass the policies. You need to have durable organizations that can maintain these standards over time.
So I'm now wishing that Kate was also part of our panel. I don't know if she's still with us, but she's written a great deal about these. So I talked before about the two prongs of the New Deal response. One, you can bargain collectively, and that was seen as a very privatized system, even up the bargaining table by allowing workers to collectivize. And then you could have statutes. But you mentioned the Fight for 15, but Kate has also written about a number of hybrid forms of collective action that bring the state back in. So instead of this privatized kind of collective bargaining, which has been in its current form pretty much of a failure, you have these public-private tripartite or quasi-tripartite modes of trying to bring in some worker protections and raise standards. But that, the question of what we do is, I think we haven't talked too much about that. So where do we go from here? What's the answer if it's not just, what is it? Is it just doing better organizing on behalf of higher minimum wages, labor law reform, which has been, on labor's wish list for many decades? What do we do? Silence.
I know from the EEO standpoint, I do believe we need to invest in much more effective enforcement, because that's what you need to actually create the incentives for employers to pay attention and do the kind of audits and self-evaluation that they really need to be doing to prevent discrimination in the first place. And I think, to the point of having strong worker organizations, one of the critical ways to have stronger enforcement is to have better partnerships between the government as well as worker centers, unions, and others, where people know where problems exist, and for government agencies and others to be able to bring systemic enforcement actions where people have safety in numbers. So you're not necessarily requiring each worker to come forward and publicly accuse their employer, but because the government is there, you're sharing the facts of your experience, and that can help put together a larger pattern that could help change practices in the long term. So I think having a much more proactive enforcement effort. Another idea that I think could be very powerful is employment testing, which is an audit study of employers to better understand, where you have two people of different backgrounds applying for the same job, to understand if they're treated differently. And that kind of information can be very helpful in identifying where discrimination exists. So I think a real shift in thinking about whose responsibility it is to address discrimination is important. And right now, many of our systems seem to suggest that, well, if no worker is willing to come forward, then we don't have a problem. And we need to have a much more affirmative duty for employers to understand where the problems are, and the government as well.
So I think Jenny's mentioned a couple of really important reasons why public enforcement plays such an important role. But Sam, you might have been thinking the same thing I was while she was talking. Another reason it's so important is because mandatory arbitration agreements that shut down private litigation do not block the EEOC, for example, or any public agency from pursuing complaints on behalf of workers. Do you want to say anything about that, Sam?
Well, I mean, so that's certainly true, and there are all sorts of reasons why individual private litigation isn't going to work. I mean, you know, because it's hard to get individuals to come forward, because it's hard to find the lawyers to bring those cases if there's not that much money at stake, because often there are problems of proof, particularly in cases involving unlawful hiring, you know, unlawful discrimination in hiring, because the workers who are the most disempowered are the ones who have the most problems in all of the regards I've just described. What you're going to end up doing is, if you rely on private enforcement, is you're going to have the least disempowered lawyers getting, or least disempowered workers getting the best representation. And that's, you know, effectively what we see. I have many, many friends who represent plaintiffs in employment cases. And, you know, I've done it myself. I continue to from time to time. And you'll find the backbone of a lot of these practices is age discrimination discharge suits on behalf of, you know, disproportionately white male executives. And why is that? Well, lots of reasons related to what I've just talked about. So if you're gonna provide in the employment discrimination space, you know, representation for people who are generally disempowered, you're going to have it be public. And also, you know, it overcomes the arbitration issue. It may overcome the class issue. You know, obviously we could come up with a bunch of smaller scale reforms. I mean, you know, getting rid of class waivers and arbitration, like that's an easy one, lowest possible hanging fruit. Getting rid of arbitration agreements that someone agrees to by showing up at work the next day after they get an email overnight, or by clicking on the button to apply for a job. Again, you know, those are not that difficult to envision and would make a difference. But, you know, the bigger point is all of these legal changes are happening in part because of the change in our politics over time to a much more neoliberal kind of politics, and for all the reasons people have talked about.
Can I chime in on this with which is like, run the macroeconomy hot for a decade and, like, you know, the amazing things that 10 years of 5% or below unemployment will do to, like, improving worker power is kind of difficult to overstate. Yes, we should need legal reform, but really, like, tight labor markets would be great to have more than once every 20 years.
So that's a good opening to the question I was going to pose to you, Suresh. My impression is that the view of labor markets has changed pretty dramatically in the last couple of decades. It used to be thought that, although of course labor markets aren't perfectly competitive, they were competitive enough, and that we could fairly think about labor markets as being basically competitive. But my understanding is that from a couple of different directions, people are coming around to the view that concentrated employer power, both in labor markets and in product markets, both of which, I mean, the latter is a huge issue with the rise of these mega tech companies, for example, but that those concentrations of power are something we can't look away from anymore. We can't assume them away. Am I right about that?
Yeah, definitely on the product market. I sort of think of them in my mind as a little bit separate, in that I think the generic state of the labor market is one where, like, employers have some degree of market power, but the kind of concentrations we have in the product market right now are a feature of the particular technological and regulatory systems that we've had that's generated an enormous amount of concentration in, like, 5 companies. And so that's that is not just a problem for, you know, the economy. That's a problem for everything we've talked about. And that's probably, you know, the recent antitrust documents that have come from Congress are a good step in this direction. And really, like, one of the directions I think that there's a confluence of these things is that any, like, a transformation in antitrust law in the U.S. is needed. We're so behind Europe, for example, in antitrust enforcement. The enforcement apparatus has been largely captured by technocrats and And one of the dimensions where there's like a meeting of the minds is actually like that, you know, definitely next time we get a crack at reforming antitrust, we're going to include something on labor markets in that, where like mergers now need to be screened, not just for their effects on consumers, but also for their effects on workers. And that's like, I think, part of the next generation of antitrust law that we're probably gonna see. Or we hope.
Yeah.
Just add to that very quickly. There's a fascinating political science contribution for this initiative from Kathy Phelan, who documents the ways that over years antitrust law was actually used strategically to push back against labor market coordination between employers and labor organizations that you did see emerge in many Northern European countries, perhaps most notably Germany. And I think that presents a complicated implication for antitrust reform and labor reform, because if we want to get to a place where labor organizations are bargaining, say, sectorally, you're going to have organization of employers at the sectoral level. And that's something that we really haven't seen in the United States. Employers are extraordinarily well organized, I'd be the first to say, in politics, but when it comes to labor market organization, they've been far weaker. And so to think about ways that antitrust law combined with labor law reform can nurture that kind of coordination.
Yeah, so I think, Suresh, you said you tend to think about these two problems differently, but I'm not sure we got around to the problem so much of concentration of labor in labor markets. The problem of explicit no poaching agreements, for example, which in the low wage labor market have been increasingly uncovered, of non-compete agreements, which have just gone off the charts in terms of employers even well down the wage scale with workers who couldn't possibly have any significant competitive information being subject to no non-compete agreements, which means they really aren't even free to quit, which is supposed to be the fallback source of their power. I mean, to what extent does that all add up to something like employer, not exactly monopsony? That
no, it is
like
exactly monopsony.
But I mean, monopsony sounds like the flip side of monopoly, meaning one employer. But it's much more about oligopsony, concentration, frictions, right? That keep people from exercising their exit option.
So the way I think about it is that there's like monopsony power due to artifice, like non-competes, no poaching agreements. But then there's just like the monopsony power that's because of like the laws of physics, that you can't be in the same multiple places at the same time. And you have to commute to a workplace. You have to, all of these things that are just like about the fact that workers are bodies and people with all kinds of lives. And that just means that finding jobs as good as jobs you've got is just hard, even if the artifices were removed. And then add the artifices on top of that, and you have like an even worse situation. And then, I mean, I just want to flag that I don't know of any estimates of this, but I suspect employer-provided healthcare is a bigger barrier to mobility than non-competes or no poaching agreements. It's just like, just think of how many people are hanging on to a job that they don't like because they don't want to take that gap month of like Cobra or whatever. And so, as far as the artifices, I would almost put employer provided healthcare as like a pretty big one at the top of the on the list.
Which was the idea, right? When private firms, when unions and private firms basically came up with this deal in the 50s that employers would be the primary provider for retirement benefits and health benefits. The employer's motivation for doing that was very much to bind employees to them. Of course, at the time, they weren't quite so quick to fire workers as they are now. But you mentioned, so there's the artifices and then there's the baseline. And it's worth talking a little bit more, I think, maybe about what it is in that baseline situation. You've got one employer, you've got one employee. The economists, many economists tend to say, well, there's no power there. Each side, it's take it or leave it from either side. You can take a job, not take a job. You can quit a job. It's yes, if you have fancy skills, you have more bargaining power, but there's no power inherent in the employer-employee relationship. and you've mentioned a couple of reasons to believe that's just not true. That workers have one human body. They have an undiversified portfolio of human capital. It's all tied up in this one firm, and it's not even just their paycheck. It's their health insurance. It's their benefits. It's also their whole network of social relationships, the pattern of their day. So there's lots of reasons that the baseline, and I think that this project is trying to get at that baseline notion. And honestly, I have to say, I'd go back. I think everybody should go back and read Paul Weiler's book on governing the workplace back in about 1990, just laying out all of the reasons why the assumption of equality of bargaining power just doesn't hold up. It goes back to the notion that in labor markets, the thing that's being traded is a person with a life and an integrity. Not an article or in commerce or a commodity or article in commerce. So I think we need maybe from all these different disciplines to get back to that basic insight that animated much of the New Deal, but the New Deal way of dealing with it doesn't seem to have worked anymore. Thoughts?
Yeah, I'd just like to point out that one of the key ideas behind social democratic regimes when they picked up in the post-war era in Western Europe was to decommodify labor. And one of the chief ways they did that was to make sure that the public sector supplied a very rich set of goods, notably including healthcare, that you didn't depend on your employer for. And that's why healthcare, I think, should be universal healthcare that's not tied to your employer, should be a very top priority, but also all kinds of other things. In Europe, you don't have to save up mountains in order to be able to send your kids to college. It's just huge. You just go, college is free. In Germany, not only do you not pay tuition, they even pay young adults a stipend to attend college so they can even cover their lost wages. One of the big problems with college access in the United States is that working class people can't afford the lost wages that are entailed by full-time college study. So providing a rich suite of public benefits both strengthens workers' bargaining power, but it also it makes people's lives much freer. They don't have to be constantly worrying about this stuff, and hence worrying about how have they crossed the boss, have they insulted or tripped up, and maybe that could lead to catastrophic losses in all other aspects of their lives.
And Cindy, I think we have to rethink the fundamental assumption that in exchange for the opportunity to work, employees essentially give up all their rights over surveillance, right? You have many more rights as a consumer than you do as a worker, right? So right now we have more and more employers monitoring every aspect of workers' lives, your keystrokes, your GPS, you might have a tracking device on your phone that's also monitoring you on your private time. And employers are setting standards that are really interfering with people's privacy rights, except they have none in the workplace, or very few. And so I think that assumption that somehow in exchange for the opportunity to work, you no longer have those privacy rights or other fundamental rights, it can really chill organizing. It can chill the ability to come forward. There is not really a right to even understand how you're being evaluated when you're being terminated, how different systems are monitoring you. So I think those are part of the assumptions we make about work that are fundamentally problematic.
Yeah, so Sam, if it's not already on your list of important examples of the assumption of equality of bargaining power, I think privacy is a huge one, where the starting point for American analyses of privacy is, did you have a reasonable expectation of privacy? Well, if your employer tells you on day one or, on day 76, we're going to now be surveilling you, we're going to be subjecting you to these tests, you kind of can't get off the ground with a notion that you had a reasonable expectation of privacy. And if you sort of buy into the notion that, hey, you consented, you could have walked away, if that becomes a basis for consenting to what would in many countries be viewed as an egregious invasion of privacy, we got none. Unfortunately, this has all been left to state law, one state at a time, and it's kind of a mess. But the typical state of the law is very, very stacked against workers, as long as employers tell them what they're doing.
Yeah, I mean, and that is actually an example that's in the paper, because it is just so clear as a place where, you know, this idea of consent that's coerced effectively by the employer is nonetheless used to justify the employer making the imposition in the first place. And, you know, as legal reformers have tried to push for privacy rights in the workplace, they just keep getting tripped up on this question of reasonable expectation of privacy / consent. So I think that that's hugely important. And I also think, you know, what's nice about this discussion that we've just been having is it highlights, and particularly what Liz just said, it highlights the way in which inequality of bargaining power is really constructed by the legal regime we have. And so there are ways of limiting inequality of bargaining power by limiting what the employer can impose. And there are also ways of limiting inequality of bargaining power by giving the worker more bargaining power, by, you know, making it actually a real choice to walk away. Like if you have health care, if you have a universal basic income, you know, if you have a guarantee of a job somewhere else or whatever. I don't mean to take a position on a particular, you know, policy, but the point is, the more exit options you actually have as a worker, the more bargaining power you have as a worker, and the more that assumption becomes real. But that is based on policy decisions and legal decisions.
Any final thoughts before we wind this up?
I guess Sam's last intervention made me think of one political obstacle to achieving the sort of change that we, I think we're all talking about, but also suggests a potential solution. And that's, the obstacle is that for many workers, it's hard for them to see an alternative of what work would look like otherwise, because for so long, to use Liz's term, we've been living under this dictatorial regime with so few workers in labor unions. Very few people know someone who is in a unionized workplace who could convey the sort of protections and rights and dignity that they receive. And so I think that suggests as a potential way forward more collective action of the sort that we've seen very recently in the form of the teacher strikes, the service worker strikes, that educate workers, frankly, about what the alternatives are and what an alternative vision of the future could look like.
That's a great point. Does anyone else have some final thoughts on this before we wind it up? Well, I think this has been a really great launch to a project that is very exciting and has a lot of potential for changing the way we think about work, the way we legislate about work, the way we actually deal with our coworkers. So if there's nothing else from the organizers, I think it's been left to me to wind it up. Is that right? Okay. Well, thank you, everybody. Thanks for giving us some of your time, and we'll look forward to lots more contributions and lots more conferences in the future, maybe someday even in person. All right. Thanks, everybody.
Thanks.